Good afternoon and welcome to Thompson Coburn's webinar on Past Performance Primer. We're presenting this with Tim Nolker and Scott Lane. This is Tim Nolker speaking, and then we'll hand it off to Scott soon. This program offers continuing legal education certificates, and they will be sent once we follow the rules and verify attendance. If you're seeking continuing legal education credits for this webinar, you'll need to verify your attendance. The way we do that is that during the webinar, 3 code words will appear. When the codes appear, attendees should write them down, as you will need to provide them with the verification form and the login instructions that will be sent to you. All CLE questions should go to our CLE website, which is cle-tc@thompsoncoburn.com. Also, if you need to leave the webinar, you should log out and then log back in when you return. And with that, we're ready to begin with our overview of the program, and I will turn it over to Scott Lane.
Good afternoon, and thank you, Tim, for that introduction. As Tim mentioned, I'm Scott Lane. I'm an attorney at Thompson Coburn in St. Louis, specializing in government contract law. We're planning to cover several different areas today. First, we will explain the significance of past performance, the differences between the past performance systems used by the government, and the agency review and appeal processes. Then Tim will speak to you regarding the options to continue disputing a CPAR beyond the initial agency process. I will also talk to you about the potential bid protest implications of past performance, including developments from recent cases. As we go along, we will drop in bonus material, if you will, on some unique aspects of doing business with the government as well. To begin with, underlying all of these issues is the great significance of past performance. There are 2 main principles to be aware of here. First, from a competitive standpoint, positive past performance is essential to winning new business. Second, from an eligibility standpoint, negative past performance can be cause for finding you non-responsible or for debarment, taking you out of the competition or even the government market altogether. As an important side note here, you will see citations on this slide to the FAR, F-A-R, or Federal Acquisition Regulation. You will hear us refer to the FAR a lot today, as this is one of those bonus material pieces. But for those of you who are not aware, the FAR is a very thick, organized set of regulations implementing procurement laws. This is the rule book that applies to acquisitions by any executive agency, and it covers almost every aspect of government contracting. It is also often supplemented by agency-specific guidance. This slide highlights that there are some primary places in the FAR that speak to past performance. First, there's FAR 42.1503. This is the section that requires contracting agencies to collect past performance information. This is the clause also that hooks contracting agencies into assessing your performance and at regular intervals. It also obligates them to do so fairly, and as we will discuss later, entitles you to appeals if the evaluation is done improperly. The second one highlighted here is FAR 15.304, and it requires contracting agencies to consider past performance in negotiated competitive acquisitions above the simplified acquisition threshold. This is why agencies use past performance as a substantive evaluation factor in many of your competitive procurements, and why it is often the most important factor in so-called best value or trade-off procurements. Third, regardless of whether past performance is used as an evaluation factor, past performance must be considered by the agency when it conducts its responsibility determination. So even if your contract is awarded solely based on low price, the agency will still have to look you up in their past performance systems and deem you presently responsible before awarding you a contract. And as I mentioned previously, a history of negative past performance can also be a cause for an agency to initiate debarment proceedings against a contractor. Those are usually relatively severe cases, but it is a possibility to be aware of. For example, a client came to us last year having been proposed for debarment for failing to deliver on a number of its supply contracts. The contracting agency was clearly upset with the non-performance of the contractor and took it to the level of proposing them, and actually every individual leaked with that contractor for debarment. The point is here that the government is not a customer you want to part with on bad terms. The policy justifications for relying upon past performance information are not too complicated. As we often hear for the politically savvy expression that tracking past performance information helps to protect the taxpayers from doing business with irresponsible contractors. Its significance in any given evaluation, though, varies from the most important factor to simply being a check of responsibility. Generally, its significance should be greater when the procurement's requirements are less defined, such that the contractor's track record may be a better indicator of performance than its price or its proposed technical procedures. Next, we'd like to discuss the alphabet soup of performance evaluation systems. The most common one that you hear of is Seapars. Seapars is an online application to input performance information. The Seapars system is the focus of this presentation, and it includes contractor past performance assessment reports, which, as you'll see on the slide there, are often referred to as Seapars with a lowercase s. The next one I want to mention is the FAPIs application, which is within Seapars, and this is where information regarding terminations for cause and non-responsibility determinations may be entered by contracting agencies. Both of the systems referred to on this slide are for inputting information only. The other main system involved in past performance is PPIRS, P-P-I-R-S. While Seapars is an input application, PPIRS is the output. That is where source selection officials go to view your performance information. Also within PPIRS exists a FAPIs output module that pulls terminations for cause, non-responsibility determinations, etc., as well as registration, excluded party status from SAM.gov. With that, I'll turn it over to Tim to address the different types of Seapars.
Thank you, Scott. There are basically three types of Seapars: interim, final, and addendum. And it's important to note the different types and when they occur, because the government itself often doesn't follow its own rules. And in particular, if you are performing well under a contract and would like to get a positive Seapar into the system, it's important to be vigilant about the timing and the rules to suggest to the contracting officer and the assessing officials that they are obligated, or that you would at least like them to perform the review. Interim reports, as it notes, are required at least every 12 months or upon a significant change in the agency after 6 months. And significant change is not really defined. It's kind of a subjective criterion. Final reports are made at the end of the contract, and addendum reports are optional and cover warranty, closeout, and management issues. These Seapars are not supposed to include cumulative information, which helps contractors who have had bumps in the road and need to, or have in fact, corrected earlier problems. So it's important to look to see that your Seapar does not include information from outside the review period in question. They're encouraged to coincide with other reviews, award fees, milestone decisions, etc. And the reports are due 120 calendar days after each assessment period. There are thresholds for Seapars. For civilian agencies, a Seapar is required if the total potential value of the service or supply contract is over $150,000. For construction contracts, the threshold is $700,000. For architect-engineer service contracts, which are a special category in the FAR, the threshold is $35,000. IDIQ orders are considered together for thresholds, but may be evaluated together. And if you're new to this business, IDIQ stands for Indefinite Delivery, Indefinite Quantity contracts that call for delivery over a fixed period of time. FSS, that's Federal Supply Schedule orders, and Basic Ordering Agreement orders are considered and evaluated individually. One point here, one strategic point here to keep in mind is it's often up to the assessing officials and the contracting officer when you have a series of transactions with the government, whether or not to do one CPAR for a group of orders or whether to do a CPAR for each particular order. We also had a case recently, a couple years ago, where there were 8 delivery orders to be made to various military bases around the country. The contracts were for highly sophisticated technical firing ranges. On one of the 8 orders, everything went wrong. The client had many problems with implementation of the firing range and was close to being defaulted on the entire project. They pretty much identified the problem to be with one particular engineer who was only working on that project and not the others. So as we negotiated our way through, we negotiated, first of all, a new engineer, and then we also negotiated that the CPAR be done at the end of the project for all 8 delivery orders rather than having this one disappointing delivery order stand out by itself. So that is a bit of strategy that you may want to consider if you find yourself in that position. More on CPAR thresholds. The Defense Department maintains different thresholds according to business sectors. For business operations support, they're required if over $5 million. For services and information technology, the threshold is $1 million. And for uniquely ship repair and overhaul, the threshold is $500,000. This doesn't bar the government, however, from reporting on contracts below the threshold in special circumstances to help a small business, for example, or to document exceptionally good or bad performance. The government typically requires a CPAR for all contracts that are terminated for default. And if you find yourself in this situation, it's important to negotiate, if you are in a position to do so, to negotiate how the CPAR is handled. Excuse me. If the default is serious enough, you may also want to negotiate, and this is one of those points about dealing with the government, negotiate whether there are any suspension and debarment issues in the picture. In terms of timing, CPARs typically last 3 years. They typically last 6 years for construction and architect engineer contracts. For this reason, as we get to challenges later, we'll advise you to both be vigilant and quickly bring any sort of challenges to CPAR ratings to the attention of the contracting officer or the assessing officials so that any fixes that might be engaged in can be done quickly. With that, we'll go back to Scott and we'll talk about the workings, the procedures of CPARs and start with key roles.
So in order to understand the agency review process, there are some key terms that you have to know. First, the assessing official. This is the government employee who writes your evaluation. It's usually a program manager, a contracting officer's representative, or an IPT lead, but it could be the contracting officer or really anyone at the agency. Second, the contractor's representative. This is someone from your organization, the contractor's organization, assigned to review the evaluation and input comments or rebuttal. This person should be familiar with the day-to-day operations, the CPAR's reference material, and preferably with this presentation. Third, the reviewing official. This is the government employee who essentially adjudicates any dispute between the assessing official and the contractor's representative in the first place. This next slide shows the general process that the CPAR goes through within the agency. On the top left, we have the assessing official inputting the draft CPAR into CPARs. The assessing official generally has 120 days after the end of the assessment period to do this, although oftentimes we see that that time period is not complied with. Whenever this happens, it starts the clock for the contractor to input its comments prior to publication of the CPAR. Specifically, on day 15 following the assessing official's release of the CPAR, The evaluation will be fed from the Seapower system into the PEPR system and will be able to be used by agencies looking at your past performance. If the contractor provides its comments within the first 14 days, then its comments will feed through along with the assessing official's comments. An important point here is that the contractor can technically take up to 60 days to comment, but if it does so, then the evaluation will be in PEPRs without the contractor's comments from day 15 up until your comments are submitted. For that reason, we often advise the contractor to try and get its comments in within that initial 14-day period. Also note that after that 60-day period expires, the contractor will be locked out. If the contractor concurs with the CPAR, then it goes back to the assessing official where it is closed. If the contractor does not respond within that 60-day period, then the assessing official can either pull back the CPAR and close it or do whatever it wants to at that point. The contractor is, like I said, locked out. If the contractor disagrees with the ratings or comments, then it indicates this on the CPAR, and the CPAR goes back to the assessing official. The assessing official reviews those comments and can change the ratings as a result. The assessing official is technically not supposed to lower the ratings, and the contractor does not get a chance to revise its comments if the assessing official modifies things. So once the assessing official modifies the ratings or submits them as they initially were, it goes on to the reviewing official. The reviewing official reviews what the assessing official did and the comments. The reviewing official can then either send it back to the assessing official for more corrections or close the CPAR. Next, although many of you are probably very familiar with the CPAR content, I want to walk through a few of these blocks to make sure you understand where the information is generally coming from and how it fits in with this process. This particular CPAR is a draft that was exchanged during negotiations on some changes to a CPAR, so we obviously redacted contractor-specific information. So at the top, the first 17 or so slides or boxes are just administration information about your contract. But it's important that this information is filled out correctly so that you get credit down the road for your work. For instance, the awarded dollar value, contract award date, and the contract effort description are key fields when you have submitted a proposal to another agency and that agency looks at this record to see if you have comparable past performance. So even though these might seem like administrative fields, make sure that they're correct. Below that information is the ratings listed by evaluation area. You see the ratings over here and the evaluation areas right here. Obviously, this is a very important part of your CPAR and the one that procuring agencies down the road are going to look to get a quick look at your performance. Nearly as important, though, and sometimes overlooked, is the trend column to the far right. This reflects either a plus or a minus sign as compared to your last CPAR on the contract. And I emphasize this because we often see in bid protests that agencies look at that trend to consider whether your performance is getting better or worse. So even if you might have a very good rating in the current CPAR, a past rating of excellent might indicate that there are problems occurring to that evaluating agency. Right or wrong, this can often be considered just as important as your ratings. So below the ratings, of course, we have the assessing official's narrative and the recommendation where they fill in, given what they know about the contractor's ability to execute, would the contracting officer recommend award or not in the future? That's followed by the contractor's comments, and if the contractor disagreed with the assessment, as we mentioned above, it'll be followed by reviewing official's comments, wherein the reviewing official either concurs with the assessment or sends it back to the assessing official. So I mentioned that the adjectival ratings assigned are often the most important part because it's easy for contracting agencies to quickly infer judgments based on them. On the other hand, some agencies think they're subjective and pay more attention to the trend. Actually, the CPAR guide has pretty detailed definitions for each of the possible ratings. Here you see the definition straight from the CPAR guide for an exceptional rating. This is particularly useful when you are working with your contracting agency on what your rating should be, or when you're disputing ratings that have been assigned to you, because you might be able to point to multiple significant events and how they benefited the government. For instance, under that second bullet, to justify an exceptional rating, there are somewhat objective criteria that can be used. At this point, I want to pause to acknowledge our first secret word of the presentation. Please write this down if you need CLE credit for this presentation. It will be needed with the verification form at the end of this presentation. The word is ratings, R-A-T-I-N-G-S, ratings. So just as we went through the definition of exceptional, there are definitions setting somewhat objective criteria for each rating. I won't read all of them to you, but they're here in this presentation and taken straight from the CPAR's guide. Here's the definition for very good and satisfactory and marginal. One thing to point out on the marginal slide is that the guide says it should be supported by a significant event that the contractor had trouble overcoming and how the contractor was notified of that event during performance. Sometimes if an agency assigns a contractor a marginal rating, it may not have an explanation that really fits with that definition, and we find that that's often a tool to try and challenge that evaluation rating. Similarly, an unsatisfactory rating requires multiple significant events that the contractor had trouble overcoming. Next, I want to talk you through a few tips to ensure that you receive a meaningful review with the agency. First, a meaningful review starts with meaningful objectives on the contract. If goals are not spelled out in a quality assurance or award fee plan already, then we recommend creating informal goals with your customer. This will not only give you targets for your CPAR, it will enable you to manage expectations and make the government's reactions more predictable during contract performance. Second, maintain a repository of important events and feedback. This may sound tedious, but memories on positive feedback and performance measures can get fuzzy a year later. Third, anticipate the due dates for CPAR reports. They are due 120 days after the assessment period ends. You should get in touch with your assessing official or the contracting officer well before this time to see if you can provide informal comments on their draft, or to see if you could provide a list of important events ahead of time. Or if the agency hasn't started on a CPAR at that time, you might even take a first crack at drafting a recommendation for them, labeled as a self-assessment. All of this fosters cooperation, shows the customer that you're interested, and it may give you a chance to frame the report for them. Fourth, after the draft is entered in CPARs and you're working on your comments, keep an open line of communication with the assessing official and contracting officer. It's important to remember that you're entitled to request a meeting to discuss the CPAR. Of course, you have to do so very quickly. Next, do not let the 14-day deadline pass, or else the initial CPAR will be in the system and available for use by other agencies without noting your objections and comments. Next, people sometimes come to us because they see this problem later on the horizon and want to know when is the right time for counsel to get engaged. The answer is early, and definitely before submitting your contractor comments. The review with the agency itself is the most cost-efficient and timely opportunity to resolve a potentially harmful CPAR dispute. The next slide, contractor comments should make use of the rating definitions. For example, as we noted above, the guide includes definitions and types of evidence that should support each rating. Applying these definitions to your performance can reduce the subjective nature of the evaluation. Along these same lines, to the extent possible, your comments should refer to objective metrics or specific feedback, emails, letters, commendations that you receive from your customers. And the last one here is we know that past performance can seem personal and is sometimes used by agencies to lash out at contractors. But please remember that the ultimate conclusion on the performance evaluation is largely in the discretion of the agency, and fighting it beyond the agency is a challenging process. So your comments must maintain a respectful tone to keep dialogue open. And with that, I'll turn it back to Tim to talk about the options after the CPAR has been reviewed to continue to dispute it.
Thanks very much, Scott. If your efforts to correct a negative, possibly defective CPAR have not yet borne fruit, there is the possibility to continue disputing negative CPARs or defective CPARs through litigation. A word, again, as Scott mentioned earlier, a word about government contracting principles, though, that come into play here. In disputes with the government, the topic of sovereign immunity comes into play. No one is allowed to sue the federal government unless the federal government has waived sovereign immunity and consented to be sued. The important part to remember as you begin to litigate claims, including CPAR claims with the federal government, is that the government writes all the rules. Any waiver of sovereign immunity, in other words, is given only on very narrow terms as defined by the government and explained by the government. And we'll make a couple references to this as we go along. But as you can see, there have been several jurisdictional battles over the past few years about who has jurisdiction to consider disputes over performance ratings. People typically want to go to the GAO, which is a primary forum for bid protest. But in this context, the GAO will not hear any direct challenges to the ratings or the CPAR. Any other challenges are dismissed summarily as matters of contract administration. But again, the whole area of bid protests, which Scott will highlight later, are fertile ground for challenging CPAR ratings. Federal district courts do not have subject matter jurisdiction to consider disputes regarding performance evaluations. And again, we have case sites here that show where this has been litigated fairly recently. It has recently been established that challenges to performance evaluations do fall within the purview of the Contract Disputes Act. This, again, the Contract Disputes Act is a waiver of sovereign immunity, so its terms need to be strictly followed. It's recently, the Contract Disputes Act generally requires that a contracting officer's final decision be reached prior to any sort of litigation in the Court of Federal Claims or the various boards of contract appeals. And there are certain specific requirements here we'll mention later. After that, again, the opportunity is to go to any of the boards of contract appeals, usually the Armed Services Board of Contract Appeals, covering anything related to the DOD, or the U.S. Court of Federal Claims. A word about the contracting officer's final decision. A request for a contracting officer's final decision or a claim, again, as I mentioned, is a jurisdictional prerequisite to suing under the Contract Disputes Act. The terms here, and they're laid out in the Contract Disputes Act, must be strictly followed. The claim also, in addition to being a prerequisite to further litigation, it does provide an opportunity to include the contracting officer in the discussions and to test his or her resolve. As Scott mentioned earlier, a lot of CPARs engage the contracting officer, but a lot do not. And it's important to carefully take this step. And again, since the life of CPARs is only 3 years, to resolve any disputes as early as you possibly can. More about the contracting officer's final decision. It's important that the claim be submitted after the CPAR has been closed. The Court of Federal Claims has held that the contractor comments themselves are insufficient to implicate the Contract Disputes Act process. In other words, we've had clients who have come to us and said, don't worry, I've already teed this up. We're ready to go to the court or the boards because we have made our claim to the contracting officer. Well, claims arguing that the CPAR is either defective or in some ways not fair, not right, contained within the CPAR process are not a request for a final decision from a contracting officer. And again, that's a jurisdictional prerequisite. The closed CPAR itself is not considered a final decision either. The claim itself must be separately made and sufficiently distinct from the CPAR reviewing process. And again, some of this is intuitive, but it's important to mention the claim should identify substantive defects in the CPAR as well as procedural defects if applicable. We've outlined some of the procedures, and we'll give you some examples later of where procedures have not been followed and, in fact, have been criticized by at least 3 federal agencies. Although the statute of limitations generally under the Contract Disputes Act is 6 years, the impact of a negative CPAR is immediate. It can bar you or limit you from getting contracts that may be already in the procurement process as your negative CPAR comes out. It's important then to bring any claims as quickly as possible. The claim made to the contracting officer should demand a decision within 60 days per the regulations. Sometimes contracting officers sit on these and simply don't make a decision. If there's no decision issued, and it's perfectly proper to remind the contracting officer of his or her duties, but if no decision is forthcoming, you can go to the boards or the court and argue that the claim is deemed denied. Let's talk a little bit about the Court of Federal Claims, and this kind of goes under the category of forum selection and strategy for going to either the Court of Federal Claims or the Boards of Contract Appeals. First of all, in going to the Court of Federal Claims, you have 1 year after the contracting officer has made a final decision or it's deemed denied. For a long time, the Court of Federal Claims declined to hear any such claims, but under a line of cases just a few years ago, Todd Construction and the BLR Group of America cases, the Court of Federal Claims concluded that it did have jurisdiction under the Contract Disputes Act. We now move to our second magic word, which is performance. If you could follow the same procedure as with the last one, we'll have your CLE in place. Before I talk further about the Board of Contract Appeals, the various Boards of Contract Appeals, I want to note some of the differences between the Court of Federal Claims and the Boards of Contract Appeals. First of all, you have, as I said, 1 year to go to the Court of Federal Claims. You have a shorter time frame with the Board of Contract Appeals. It's 90 days. The Court of Federal Claims tends to be a more formal procedure. It tends to run almost like a regular federal district court in terms of its discovery and various pretrial activities and hearings and whatnot. No jury trials, but otherwise it works a lot like federal district court. This can cause further expense for some contractors, and it's really worth considering when you compare it with the Boards of Contract Appeals. You also get, in the Court of Federal Claims, lawyers from the Justice Department entering to represent the agency rather than at the Boards of Contract Appeals, where the agency lawyer, who may already be familiar with the CPAR, if not the procurement itself, on the other side. So there are some strategic concerns there to consider, whether you want a new set of eyes looking at the process, even though it may be a little more cumbersome, a little more expensive in the Court of Federal Claims. Historically, the boards also denied to take jurisdictions over these claims unless there was a specific clause in the contract that allowed for this. However, in Kelowna Shipyards, shortly after the BLR decision came out, where we actually represented BLR, by the way, but shortly after the decision came out, the Armed Services Board of Contract Appeals decided Kelowna Shipyard to the same effect of allowing jurisdiction in the Board of Contract Appeals. Another issue that you may want to consider in forum selection going to the Boards of Contract Appeals is that the procedure is slightly more informal in the Boards of Contract Appeals. You get assigned a judge fairly early on, and in our experience, this isn't written anywhere, but in our experience, the board judges tend to get more personally engaged with cases and can be approached about schedule and discovery issues and all kinds of issues a little more easily than the formal motion practice in the Court of Federal Claims. Of course, it requires both sides approaching the judge, as you know, or as you lawyers know, but again, the procedure is a little more informal and works to reduce expenses often. What standard of review is applied here? The FAR creates two distinct sets of requirements for the government to follow in CPARs. First of all, the government has to follow its procedures. And second, it has to provide, according to the courts and boards, a fair and accurate performance evaluation. Procedural errors are reviewed de novo. In other words, from a blank slate. There is no deference paid to the activity of the assessing official or the contracting agency when procedural errors are reviewed. In order to avoid problems, though, with standing and redressability, the complaint must tie specific procedural flaws to some sort of prejudice in the evaluation. You can't just challenge a CPAR for being not procedurally correct if you weren't hurt by it, in other words. Substantive errors, and this is really the important part, are reviewed for abuse of discretion. That's a well-known standard in the legal community where there is some deference paid to the officials who have made the decision that's being challenged. You can't simply say the decision is wrong. You can't simply say we've been damaged. You must show arbitrary and capricious conduct by the government. Again, mere disagreement is insufficient. Some issues to consider. Were the contractor's shortcomings excusable? And again, as Scott mentioned earlier about keeping records, and I know this requires resources to be expended early on in contract performance, but it should be easy in many situations to show that the contractor's shortcomings were excusable. There may even be government concessions made on problems that had developed earlier. Did the government itself share in the fault? Often this is the case. Did the government ignore or misstate significant facts or metrics? Did the government, and this is a classic one that often leads to claims in litigation as well, did the government hold the contractor to requirements beyond those in the contract? Often this invokes the changes clauses and the disputes clauses. Also, as Scott alluded to earlier, has the government identified a serious event and an impact to the government in order to justify those two lower negative ratings we talked about? And finally, speaking of prejudice, did factors outside the contract performance influence the ratings? The remedies are not exactly what some contractors would hope for here. Basically, the remedies in both board and Court of Federal Claims situations are a declaratory judgment, declaring the CPAR to be in error or defective or unfair and wrong. The boards and courts will not rewrite the CPAR. They will only remand with proper and just instructions to correct the evaluation. Also, for the small businesses out there, Equal Access to Justice Act fees and costs are available. A word about other remedies. Injunctive relief is very difficult to get. It's absolutely unavailable at the boards of contract appeals. It may be available at the Court of Federal Claims, but in very limited circumstances. And those circumstances really generally involve holding the parties fast, standing fast, maintaining the status quo till a decision on the merits can be reached. But you're extremely unlikely to get any sort of decision on the merits using the injunctive process. No lost profits can be gained, and no defamation damages can be gained. Contractors often want to sue the government for defamation because of negative comments in CPARs. And again, those damages aren't available because nowhere is there a waiver of sovereign immunity that allows for that. The other waiver of sovereign immunity that's often used in addition to the Contract Disputes Act we mentioned earlier is the Federal Tort Claims Act, but that does not include defamation damages. We also advise clients at this stage of the proceeding to consider alternative dispute resolution. This has been very helpful. We've used it with both the Court of Federal Claims and the Boards of Contract Appeals, and we're fans of it. It has worked well for our clients, and it's been efficient and reduced expenses And again, we do recommend it. Mentioned earlier some criticism of the system, and it's good to look at these kinds of reports and activities because it could provide some further argument for contractors when they're challenging negative CPAR ratings. February 1 of 2016, the Inspector General of the U.S. Department of Defense issued a scathing report on many procedural errors and basically neglectful procedures or activities in implementing procedures under CPARs. More recently, the Air Force also took a look and had the same sort of conclusions about Air Force contracts, and all of these can help contractors develop arguments in their defense in challenging or in observing whether or not the assessing officials and contracting officer have followed the proper rules. The Army itself, again, part of DOD obviously, but the Army itself has also come out with a similar report this year. So all of those, contact us if you'd like the full reports, but they're very lengthy, but we'd be happy to supply them to you if you are interested. A word about competitive strategies. It's pretty clear by now that bad performance ratings and evaluations hurt winning new business. Depending on the circumstances, when you are going for a future procurement, when you are competing, it may help you to actually spell out what happened in a negative performance rating on a similar contract within the past 3 years to try to take the sting out of it for the selection officials as you compete for new contracts. In fact, the FAR at 15.306D3, as you can see there, requires agencies to allow you to explain negative past performance information that you have not had an opportunity to respond to. This, however, in negotiated procurements is only a right if you make the competitive range. We'll see later a brief case where contractor was excluded from the competitive range, but excluded not because of technical or cost issues with its proposals, but because it had a neutral past performance rating, which the boards did not allow, and actually it was the GAO, and granted a bid protest, putting that client back into the competitive range. Should also, this should come earlier, but you should also be careful about which persons you identified in your past performance information on those future procurements. Further competitive strategies, again, it takes assets, we know, but it's important to keep a diligent record of your company's past performance. It's important you will be given computer identifying information and passwords to check on your company regularly in the CPARS and FAPIS systems. It's important to perform due diligence on your subcontractors to make sure that either they or maybe your teaming partners have not had negative performance ratings. Also, from a competitive advantage, it's important to note if you determine this, and a lot of this is confidential, but if you can determine that competitors have had negative performance ratings, maybe they've lost bid protests involved in negative performance ratings they've had, that can be advantageous information as well. Keep in mind, too, that every solicitation, and we often start out saying, be sure to read the contract, and we don't mean to be flippant about that, but so many people know a fair amount about some parts of government contracts, but not the whole picture. And it's important to keep in mind that each solicitation can be a little bit different. Be very careful to review the performance evaluation factors, and it's important and even required if you have a concern about the way those factors are applied to consider filing a protest before the bids are due. With that in mind, and when Scott mentioned his background, I also mentioned he's one of our experts on bid protests, so I will turn it back to Scott to discuss bid protests.
So Tim has talked about continuing to dispute Seapower ratings. This next section is about how past performance becomes implicated with a different type of dispute referred to as a bid protest. And as a backdrop and another bit of bonus material, there's essentially two types of bid protests. First, there are pre-award protests. This is where you're challenging the terms of the solicitation, such as an RFP that requires you to incorporate a particular brand name product, and you believe that's unfair. Or if the past performance evaluation criteria are unclear or improper. This is where you're challenging something that is apparent on the face of the solicitation, and the distinction is critical in terms of timing. A pre-award protest can only be filed prior to submitting your bids or offers. The rationale is simple. Can't wait to see if you lose before protesting a poorly written RFP. This would essentially give you 2 bites at the apple. The second type is a post-award protest. This is the most common bid protest, and it's easiest to understand. In essence, this is where you're challenging an award that has been made to a competitor. You might contest the reasons that you were disqualified, the evaluation results, the agency's evaluation, or the agency's conduct during discussions. There are 3 different forums in which you could file a protest. The option that is the least adversarial is an agency-level protest. Rarely, though, is this a recommended path because you're essentially asking the agency to reconsider a decision it has already decided against you. It's unlikely the agency is going to change its mind unless you have some unusual circumstances. The most common bid protest forum is the GAO, the Government Accountability Office. They have a special group of government attorneys whose sole job is to decide bid protests on an independent basis, a different group of attorneys from those that issue reports that you hear referenced in the news. Unlike agency-level protests, you get access, or your counsel at least gets access, to the agency's evaluation documents, and the GAO is required by statute to decide that protest within 100 calendar days of it being filed. The third forum, and another lesser-used one, is the Court of Federal Claims. The Court of Federal Claims is most often where a protester goes if they lose at the GAO. It's not technically an appeal, but it's generally a more in-depth process that increases time and cost, so it often becomes a last resort of sorts. There are, of course, certain issues that the court has developed more favorable positions on than on the GAO that lead some protesters to choose that forum at the outset instead. Another point of background is that it's not just losing bidders that are involved in bid protests. In the vast majority of post-award bid protests, the awardee is permitted to intervene in the protest, and its job is essentially to help the agency support its award decision, or it could just monitor the case to ensure that the agency does not cave to the protester undeservingly. So how does past performance come into play here? Well, the GAO will not consider protests challenging your Seapower ratings. As mentioned above, the FAR puts a lot of emphasis on contracting agencies to use past performance information, though, in support of its award decision. And so past performance is often an evaluation factor or even the most important evaluation factor. This is where the GAO gets concerned with whether the evaluation was reasonable. For example, in the Tri-Centurion case noted on the slide, an often cited case at the GAO. There, Tri-Centurion protested an award to another contractor for Medicare Program Administration services. The GAO ruled in favor of the protester on several issues, one of which was that the agency's evaluation of past performance was inadequately documented by the agency, which was CMS. In that case, there was no write-up by the agency explaining why it considered the awardee's past performance references to be relevant to the current solicitation. In addition, the GAO found it problematic that the agency gave credit to the awardee for past performance of its proposed subcontractors without first considering whether those subcontractors would be performing significant roles on the pending procurement. For those of you tracking CLE credit, the next secret word to write down is standard, S-T-A-N-D-A-R-D, standard. Another type of past performance issue that comes up in GAO protests is where an agency uses an offeror's negative past performance to deem that offeror as non-responsible. As you may already know, prior to awarding any contract, an agency must assess whether the apparent awardee is a responsible contractor. Contractors often associate this with their status in SAM.gov, but technically this determination is made by agencies based on their review of the contractor's profile in PEPRS, which has a feed from SAM.gov, but also shows the offeror's past performance history from CPARS. In the Erdal-Kamilski protest, the contractor protested the rejection of its proposal based on having been deemed non-responsible by the contracting agency in that instant procurement. In particular, the agency was concerned about a record it found where the contractor had been terminated for default. During discussions, the agency asked the contractor about the matter, and the contractor replied generally in writing stating that the default was not its fault because it happened under a joint venture contract, essentially blaming its other joint venture partner. The response did not change the agency's view. The agency said it was unsatisfied because the contractor didn't explain why the situation could not occur again. In addition to evaluating the offeror's past performance as unsatisfactory, so the contracting officer deemed the contractor non-responsible. The GAO found the agency's decision was reasonable and denied the contractor's protest. On the other hand, the Afghan-American case provides an example of a protest at the Court of Federal Claims, wherein the court determined that the agency was unreasonable in its determination that the offeror was non-responsible. It's a somewhat unusual determination because that is a decision that's highly grounded in discretion for the contracting officer. But that case has a long and somewhat suspenseful storyline involving allegations of bribery and forgery against a contractor in a war zone, with criminal investigations and a proposed debarment that was ultimately overturned. The Army's errors were largely related to not providing the contractor a reasonable opportunity to respond to those criminal allegations and debarment allegations before excluding it. And the agencies relied on investigative reports that were actually deemed flawed by the Army's own suspension and debarment officer. And the last case on this slide is Contract, a GAO protest where the contract protested an award using information it found online about the awardee. In that case, the awardee had received an excellent past performance rating, but Contract found a DoD report online discussing problems of one of the awardee's recent contracts. The protester used that case, or that report, to argue that the agency failed to consider negative past performance of the awardee. During the course of the protest, and by reviewing the record that the protester's counsel was afforded during that protest proceeding, Contract discovered additional adverse instances of past performance. The GAO found that the agency did not document its consideration of those adverse references and upheld Contract's protest. With that, I'll turn it back over to Tim to discuss some additional recent cases.
Recent case developments really provide some finer points in elements of past performance evaluations, and they offer guidance for contractors in doing business with the government and in preparing for future procurements. The first one, TradeLinks General Trading, was a best value procurement. In other words, price was not the top or even not the sole or even the top determining factor. The top determining factor in this procurement was past performance. But this case showed where two competitors came in bidding for, basically it was equipment repair and maintenance at a U.S. base in Kuwait. The top rating of substantial confidence to the protester still did not justify an award where the protester bid $2.5 million as opposed to a satisfactorily rated contractor who bid $1,700,000. So it didn't justify a 1/3 increase in the price of the contract. In the next case, so Clifton Larson Allen LLP for accounting services, we get a better look. This was a best value procurement as well. And this case stands for the proposition that in a best value procurement, the government will pay a higher price, $4.9 million versus $4.7 million, when the past services proposed to be reviewed by the low bidder were not as close a match for the services to be provided, and even high ratings have been given. In Sevenson Environmental Services, again, it's just a case that shows this was a protest of a task order in excess of $10 million, which, by the way, is the threshold. For task order contracts with the federal government, you cannot protest orders that are under $10 million. But here, the protest was denied where the GAO found that the company that received the award had past performance submissions that were not identical to the task required, but that the agency reasonably evaluated the proposals in their entirety. So your past performance information submitted doesn't have to be identical to the task you're bidding or negotiating to perform. On the other hand, Halbert Construction Company shows where the agency went too far and considered past performance for a project that did not sufficiently match the solicitations criteria. So you may ask, what's a contractor to do? There's not a lot of guidance here, but the closer together the parties are, the more the GAO is likely to deny the protest and side with the awardee. And also, I used the term reasonable there. It's important that we get down to when we get down to these finer points, that the issues really involve whether or not the procuring officials acted reasonably in reviewing this information, which admittedly is sometimes subjective. SureTech Pharmacy, Piedmont LLC, demonstrates another point about bid protests that certainly apply when past performance is at issue in bid protests. Here, you may have seen that other than the Equal Access to Justice Act, it's hard to get attorney's fees and costs against the federal government. In this bid protest context, however, winning protesters, even if winning the protest does not mean they win the award, they win a reprocurement is what they win, but in certain circumstances, protest costs, which can be substantial, are awarded when clearly meritorious protests are brought and the government has just not acted well. Here, in SureTech Pharmacy, protest costs were awarded when the challenges to the past performance reviews were clearly meritorious and the agency, here the Veterans Administration, dragged its feet in taking corrective action and addressing the issues. Extreme Concepts is a case I referred to earlier that had the protester removed from the competitive range and barred from further activity on that particular procurement because it had a neutral past performance rating. That was its only problem, so far as the government knew, because the government declined to review the rest of its proposals. So again, Extreme Concepts won that bid protest. And the final one is very instructive. We have potential clients and clients often coming to us saying, we received a satisfactory rating and it should have been very good and this will hurt us and we want to challenge this. And we usually encourage them not to because, again, of that element of subjectivity that's allowed to the procuring officials and the fact that boards and courts just aren't very sympathetic to raising a satisfactory rating to a very good rating. If the client or contractor has truly been negatively impacted, then this can have some appeal to the boards and courts. So in HP Enterprise Services and Aon National Flood Services, we have a fairly large government contract. It was a best value procurement of around $100 million. It was protested on many grounds. There were 11 lawyers representing the couple of protesters in this case, which did not succeed, by the way. The basic argument in terms of past performance was that protester argued that its satisfactory rating should be raised, and showing a little bit of chutzpah, argued that the awardee's satisfactory rating should have been lowered. The board was not impressed and deferred to the judgment and the discretion of the agency's officials and found that they had acted reasonably. So that brings us pretty much up to date with very recent developments, and wraps up our portion of the presentation. We hope it's been valuable to you. And I know we're over the time, but if we have any quick questions here, we'd be happy to take them.
While you're typing those in, a quick plug for our next government contracts webinar we'll be doing. You see the information up on the slide there, April 26th, where I'll be presenting with Kim Nucci from our Washington, D.C. office on government agency corrective actions, specifically in the bid protest context, and how those can impact both awardees and protesters. You can sign up for that to see on our firm website at the link shown there.
Our contact information is here, and we invite any further inquiries that you have to either Scott or me, and we also invite you to fill out the evaluation forms to help us improve these webinar presentations. We thank you very much for your participation today, and look forward to talking with you more in the future.